एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए.
Welcome to all for yet another session of Goa State Legal Service Authority's virtual Juridicare series. I, Shri Jude Sequeira, Civil Judge, Junior Division and Judicial Magistrate First Class, have privilege and honor to introduce our guest speaker, Srimati Ashwini Khandolkar, Civil Judge, Junior Division and Judicial Magistrate First Class, Panji, who will enlighten us on topic protection of trade secrets in India. On account of rapid increase in trade and commerce and its competitive nature, every business entity needs protection for its trade secrets. With this brief introduction, I request a speaker to take over and enrich us with useful insight on trade secrets and protection.
On the occasion of World Intellectual Property Rights Day, I am going to speak on protection of trade secrets in India. A business during its course accumulates and creates a lot of valuable information. This could be customer list, business models, formulas, algorithms, in-house softwares, manufacturing process, technological know-how, etc. All this information is a trade secret of the said business. The Honorable Delhi High Court in the case of Ambience India Private Limited versus Naveen Jain observed that a trade secret is some protected and confidential information which the employee has acquired in the course of his employment and which should not reach others in the interest of the employer. However, routine day-to-day affairs of employer which are in the knowledge of many and are commonly known to others cannot be called trade secrets. A trade secret can be a formulae, technical know-how, or a peculiar method or mode of business adopted by an employer which is unknown to others. Information which is duly protected by its owner and which can be potentially damaging to its owner if it is disclosed would get covered as trade secrets or confidential information. Unlike patents, copyrights, trademarks, trade secret is not an intellectual property right, as in there is no exclusive rights protection. The protection is a remedy for breach of trade secrets. To qualify as a trade secret, any information must be firstly a secret, secondly must have commercial or economic value, third the owner must have taken reasonable measures to protect the information as a secret. The exceptions would be independently developed information by the competitor or any product that is reverse engineered. The advantage of keeping information as a trade secret would be cost saving and its long-term use. Let us take, for example, a formula for making soft drinks which cannot be easily reverse engineered. For patenting this formula, it will have to undergo the test of patentability. That is, it will have to be novel. A slight improvement from already known formulae may not pass this test. Besides, it will require license from the original patentee. If the formula is registered, the protection will be for 20 years, after which the information will be in public domain. Patents also require a full and complete disclosure of the invention. Besides, there are costs for registration and for renewal. However, on the other hand, if this formula is kept as a secret, it can be protected as long as it is kept as a secret. The cost borne will be for taking measures for protecting it, like installing security cameras, biometrics, drafting non-disclosure agreements, etc. But the benefits can be reaped as long as the formula is kept as a secret. If we look at our tradition and heritage, we will see that trade secrets is the oldest form of intellectual property. Internationally, TRIPS, that is trade-related aspects of intellectual property rights, is the first multilateral international agreement to focus on trade secrets or confidential information. According to Article 39(2) of the TRIPS Agreement, there are three criteria that have to be taken into consideration, as we had seen before. One, that generally the information is not known among or readily accessible to persons that normally deal with this kind of information. Secondly, the information has actual or potential commercial value because it is a secret. Third, the person lawfully in control of the information has taken reasonable steps under the circumstances to keep it a secret. The footnote to Article 39.2 of TRIPS Agreement elucidates that legal remedies should be available to address breach of such confidential information, especially when the breach is through not honest practices. TRIPS allows its member countries to address this issue either through a dedicated law or through common law system. In our country, as of today, there is no set legislation or dedicated law for the protection of trade secrets. The recourse is to common law. The principles for deciding matters relating to breach of trade secrets is equity. The civil remedy in the case of infringement may be injunction or damages. Our Information Technology Act 2000 and its subsequent amendments covers theft of confidential information through electronic media. And it also mandates stiff penalties, damages and imprisonment. The other criminal remedies would be for theft and misappropriation of property. The Indian case laws have tried to address various aspects of trade secret protection, whether it is defining trade secrets, confidential information, or the grounds under which trade secrets can be protected, or the scope of remedies. While the Indian courts have drawn extensively from English case laws, they are now increasingly relying upon the growing body of domestic jurisprudence on trade secret protection. In Fairfest Media Limited versus ITE Group, the Calcutta High Court has observed, the essence of this branch of law, whatever the origin it may be, is that a person who has obtained information in confidence is not allowed to use it as a springboard for activities detrimental to the person who made the confidential communication. One of the reasonable means to protect trade secrets is by use of restrictive covenants in business agreements. A study of our case laws shows that Indian courts have upheld these restrictive covenants like confidentiality and non-competition. In Niranjan Shankar Golikari versus the Century Spinning and Manufacturing Company, our Honorable Apex Court has held that negative covenants operated in the period of the contract of employment cannot generally be considered to be in restraint of trade. It is also stated that negative covenant that the employee not engage himself in a trade or business or get self-employed and perform similar or substantial similar duties is not a restraint of trade unless the contract is excessively harsh or unreasonable or one-sided. It is to be noted that the restraint should not be greater than necessary to protect the employer, nor unduly harsh or oppressive to the employee. Trade secrets, by its very nature, is confidential information or technical know-how of value to the owner and duly protected by him. An important concern, therefore, in trade secret litigation would be how to protect this from making the information public during trials. Can trade secrets be protected against inevitable disclosure during court trials? This issue was addressed by our Honorable Apex Court in the case of Naresh Sridhar Miraskar and others versus State of Maharashtra and others. This case concerned defamation suit. One of the witnesses had requested that his evidence should not be given any publicity. What our Apex Court observed was that the Code of Civil Procedure contains no express provision authorizing a court to hold its proceedings in camera. The court has inherent jurisdiction to pass an order excluding the public when the nature of the case necessitates such a course to be adopted. It observed that Section 151 of the Code of Civil Procedure 1908, by giving the courts inherent powers to make such orders as may be necessary for the ends of justice or to prevent abuse of the process, enabled courts to decide whether or not to have trials in camera. This decision, nevertheless, has to be entirely based on whether this would aid the administration of justice itself. Elaborating upon the broad exceptions to hold public trial, the Apex Court observed that trial in closed session is generally ordered to prevent publicity which is likely to deter parties or their witnesses from giving evidence on account of the nature of the evidence, such as matters publication of which may harm the interests of the state or the public at large, for instance, disclosure of official secrets or matters which lead to publication of secret processes, publication of which would destroy the very basis of the claim for relief, etc. Thus, we can see that whenever there is any trade secret to be disclosed during a trial, the court can use its inherent powers under Section 151 CPC and can hire these trials in camera. To conclude, there is no legislation for the protection of trade secrets. The law presently flows from Indian jurisprudence. However, there are few judicial pronouncements, and therefore we can say that the trade secrets law in India is still in its nascent stage. The law of trade secrets is still evolving, and efforts towards its protection will provide a more healthy business and also a more healthy competition. Finally, I would like to thank the Goa State Legal Services Authorities for giving me this opportunity to speak on the occasion of the World Intellectual Property Rights Day. Thank you.
On behalf of Goa State Legal Service Authority, I express my profound gratitude to Srimati Ashwini Khandolkar for sharing with us insight on the topic protection on trade secrets in India. I am sure all our viewers will be certainly enriched with all the details on a topic which is getting more significance in present times. Once again, thank you very much, and don't forget to tune in to our next edition next week same time. Do like, share and subscribe to this channel. Thank you.
राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळून दिता.
वेळार योग्य कायदा खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चड काळच्या केसीक बेगीन सोपयता
आणि ते बी सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागी संपर्क करा
वा टोल फ्री नंबर 151000 चेर फोन करा.